Business associations. Formation of principal and agent relationship. Agency exists when a principal authorizes an agent to act on their behalf. Mutual assent, benefit, and control. Agreement. Agent works for the principal's benefit and is subject to the principal's control. Capacity. Principal for contracting, agent minimal, may be a minor. Contract formalities are only required for statute of fraud issues. Duties and remedies for breach. Good faith and fair dealing. Principal to agent, by contract, compensation, cooperation, reimbursement. Remedies for agent, terminate agency, seek damages. Agent to principal, duties of care, loyalty, obedience, and communication. Remedies for principal, discharge, withhold compensation, seek damages, seek indemnity. Principal liability for agent contracts. Agent's actions bind principal when acting under actual or apparent authority. Actual can be express or implied. Express, expressly authorized by the principal. Implied, agent reasonably believes they have authority as necessary by custom or prior dealings. Apparent, third party reasonably relies on the appearance of authority of the agent to bind a principal. Ratification, principal subsequently approves the agent's actions by word or actions. Principal liability for agent torts. Respondeat superior, vicarious liability when agent is within the course and scope of duties to principal. Independent contractors not liable other than for ultra-hazardous activities and non-delegable duties. Intentional torts, only for authorized actions, natural result of duties, bouncer, for the benefit of the principal. Partnership, general partnership. Formation, two or more parties agree to conduct business for profit, no filing required. Rights and duties, unless otherwise stated in an agreement, equal rights to manage and profits, the ordinary affairs of the business. Agent, each partner is an agent for the partnership with authority to bind the partnership. Relations with third parties. Debts, partners are personally liable. Contracts, each partner is an agent for the partnership with authority to bind the partnership unless otherwise stated in an agreement. Liability, all partners are jointly and severally liable for all contracts and torts committed within the course and scope of the partnership. New partners are not liable for debts prior to joining the partnership, but any money paid into the partnership may be used to satisfy such debts. Outgoing partners remain liable for debts barring release or novation. Dissociation, dissolution, and winding up. Dissociation terminates a partnership if there are only two partners. It may be voluntary or involuntary, and the partnership must buy out the dissociated partner. Keep in mind that if there are two partners and the partnership breaks up, it's a sole proprietorship. This buying out the dissociated partner is for a partnership that has more than two partners. Dissolution occurs when a partnership stops being active and business is wound up. Winding up is a process of paying off creditors, partners who have loaned money to the partnership, capital contribution of partners, and distribution of profits and surplus among the partners. Limited liability partnerships must register with state. No partner is personally liable for partnership obligations. Corporations shields owners from personal liability for corporate actions. Piercing the corporate veil, abuse of corporate status to reach the assets of the shareholders. Not in the definition sheets here, but keep in mind, piercing the corporate veil is for closely held corporations only. You're not going to pierce the corporate veil of a major multinational corporation. That's not going to happen. A court may pierce the corporate veil for the following: alter ego, undercapitalization, or fraud, AUF. Alter ego, using corporate status for personal reasons, typically lacking in corporate formalities. Undercapitalization, inadequate funding to cover costs of doing business. Fraud, most likely in tort rather than contractual obligations. Promoter, prior to incorporation, gets the ball rolling. Liability, personally liable for pre-incorporation contracts unless by agreement, novation, corporate adopts contract, or accepts benefits. Duties, good faith and fair dealing. Formation, de jure, properly incorporated, corporate name, number of authorized shares, address of initial registered agent, and names and addresses of each incorporator properly filed with the Secretary of State. De facto, good faith yet unsuccessful attempt to incorporate may shield shareholders from personal liability. By estoppel, reasonable belief that a corporation exists or incorrectly holding out a business as a corporation prevents one from denying corporate status. Within that definition, understand that it prevents anybody from denying it, whether it be the people who incorporated or somebody else who's doing business with the corporation believing that it was actually successfully done. Powers. Ultra vires acts. Acts outside of corporation's stated purpose. Debt acquisition. Borrow funds from outside sources. Corporate management. Directors and officers. Duties. Care. Act as a reasonably prudent person in good faith and in the best interest of the corporation. Business judgment rule, BJR. The presumption that directors and officers will manage in good faith in the best interest of the corporation as a reasonably prudent person in the same or similar circumstances. Now that above is not the exact wording, but I edited it to be closer to the rule in negligence because it is easier to remember this way. The BJR does not protect those in conflict of interest or fraudulent activity. Loyalty. Place the interests of the corporation above their own. Duty of loyalty equals conflict. Conflict of interest, self-dealing. Entering into a contract with the corporation or having financial interest in a contract. See defenses for AAF below, basically approval and fairness. Usurping corporate opportunity. May not personally act on a business opportunity without first offering it to the corporation. See defenses under AAF below. Unfair competition. May not unfairly compete with the corporation. Again, see the defenses below. Disclose. Material information relevant to the corporation required for approval. Defenses. This is AAF, which consists of approval of and in fairness with the corporation. Approval of disinterested directors. Approval of disinterested shareholders. Fairness to the corporation. Shareholders. Suits. Direct for breach of fiduciary duty owed to the shareholder. Derivative on behalf of the corporation, SAD. Must own stock, standing, adequately represent the corporation, and make a demand on the directors to bring suit, unless doing so would be futile. Duties. Controlling, major, shareholders have enough voting strength to substantially impact the corporation. They owe a fiduciary duty to the corporation and a duty of care and loyalty to minority shareholders. Voting agreements must be in writing, signed by all parties, and is generally non-revocable, with no limit on duration. Voting trusts, limited to 10 years, ownership of the shares transferred to the trust, trust agreement provided to Secretary of the Corporation. Watered stock, stock issued at a price greater than market value. Instead of paying a $20,000 salary, company issues employees $60,000 of stock. A $40,000 bonus to the employee. The stock they hold is watered down. Recipient may be liable for the difference. Fundamental changes to the corporate business or structure must be approved by a majority shareholder vote. Typical procedure: board adopts a resolution, written notice to shareholders. Upon shareholder approval, articles are updated and filed with the state. Types of MAD, M-A-A-D. Merger, shareholder approval not required for insignificant changes. Asset sale, sale of substantially all assets. Amendment to articles or bylaws require approval and filing with the state. Dissolution and winding up, common sense, same as the other. Equitable subordination, Deep Rock Doctrine. Third-party creditors of an insolvent corporation are paid prior to shareholder creditors due to parent corporation's failure to properly capitalize the subsidiary. Federal securities laws. We do not need to know the statute numbers. 16B, short swing profits. Profits received within a 6-month period by a corporate insider must be disgorged to the corporation. 1. Listed on a national exchange. 2. 10 million plus in assets and 2,000 plus 500 if not accredited shareholders. Corporate insiders. Directors, officers in position at time of either purchase or sale. Shareholders who own more than 10% equity stock at the time of both purchase and sale. 10b-5, insider trading, provides liability for any person trading securities based on non-public corporate information. Insider, holder of non-public corporate information. Tipper, provides information. Tip E, receives information. Misappropriators, obtains information through other means. Fraud, misrepresentation, requires intent, material misrepresentation or omission, reliance, sale or purchase of securities, interstate commerce, and damages. Remedy is to disgorge profits to the corporation.